Right, I think we can get started. Good morning and a very warm welcome to everybody who's joined us for this CPD Sorted event. I'm Blaise Colivers from W.consulting, and it's my pleasure to be joined today by Tasso Anastidis, a partner in employment law at Evershed Sutherland in Johannesburg. A very warm welcome to each and every one of you joining us for the session in which we will be looking at the legal implications of retrenchments in terms of the Labour Relations Act. The session is scheduled to run until 12 p.m. today, but depending on how timing goes and depending on the level of questions, it may end a little bit before then. We will be taking a short little break around about halfway through in terms of the session. And to the extent that any of you do have any questions for Tasso, please feel free to type those questions into the chat pod, or put your virtual hand up, and once you've got his attention, you can ask your question over the microphone. I'm looking forward to a very engaging and entertaining session. So I guess without further ado, I'm going to hand over to Tasso. Thank you, Tasso.
Thank you, Blaise. Thanks for the introduction. It's lovely to meet all of you. And yes, I'd like to try and make it as engaging as possible. But let's see how it goes. A lot of this is a lot of just information that I'm going to give to you, but where possible, I will try and engage some of you and just get your input on some of the slides and the information. So thank you, guys. Without further ado, yes, as Blaise explained, my name is Tasso Anastidis. I'm a partner at Evershed Sutherland. And today we're going to be looking at section 189 and section 189 capital A in regard to retrenchments. I'll also be looking out for any raised hands, and when I see that, I'll pause and deal with any questions. And you're welcome to ask questions at any point. Okay, so let's start right at the beginning and why retrenchment becomes a possibility. And there's many reasons or basis why retrenchment becomes possible. Often businesses want to make decisions that unfortunately result in employees losing their jobs. Now, some of this can be technology based. The classic example is when a machine, comes into existence, which can literally replace the job of 5 or 10 or even more employees. And what the business will do is unfortunately retrench those employees because now a machine can literally replace them. So it's quite a widely accepted basis that technology is often a good basis to retrench employees. The second one, and this is a bit more common, is where businesses decide to merge or collapse two roles into one. And we've just put a random example of a marketing manager and a business development manager. And the rationale there is that this is done to be more efficient, to streamline things, and to provide a cost saving. And then another classic example is when the business is struggling financially. If a business is not in a healthy financial position and we're looking at cutting costs. Oh, sorry, I just think I may have lost. Sorry, okay, hopefully we're back. If a business is not doing well financially and is looking to cut costs, the number one starting point is can we look at dropping a few employees to save that monetary cost. So those are generally, and this is just by way of overall summary, these are sort of the three common bases that come into existence in order to retrench employees, but it's not limited to just these three. Okay, you should hopefully know that retrenchments are governed by the Labour Relations Act, and this act, together with these two sections here, 189 and 189A, sets out the procedure to be followed in these instances. I'll touch a bit later on how all the legislation can do is explain the procedure to be followed. The legislation cannot easily explain all the basis for retrenchment. So the main intention of the legislation is to ensure that employers follow a procedure when retrenching. Okay. Then retrenchments are also known as a no-fault dismissal, because it's not, for example, like misconduct or poor performance, which is due to the fault of an employee. So because it's a no-fault dismissal and it's not, the employee is not to blame for the dismissal, employers are obliged to follow certain substantive and procedural requirements to minimize the negative impact that retrenchments have on their employees. So the onus is higher on employers to follow a fair procedure and make sure there's a good enough reason to retrench, because it's not due to the fault of the employees. Now, the LRA does distinguish between small and large-scale retrenchments and sets out a procedure for each. We will unpack that a little bit more. For now, we do highlight that large-scale retrenchments are governed by Section 189 capital A, and in order for that section to apply, an employer must employ at least 50 employees and contemplate retrenching at least 10 employees. There is a sliding scale, which we'll look at much later, but the procedures are quite different between an ordinary retrenchment and a large-scale retrenchment, and we'll unpack that as we go on. And as I've already said, Section 189, both sections are primarily concerned with procedural fairness. Okay, I mean, this notion of fairness, it's quite a interpretive term. It can be interpreted many ways. And our Labour Appeal Court, LAC stands for Labour Appeal Court, has considered this notion of fairness, especially in the context of retrenchments. And they had this, so we just quote this portion from that judgment. Fairness to the employer is expressed by the recognition of the employer's ultimate competence to make a final decision on whether to retrench or not. For the employee, fairness is found in the requirement of consultation prior to a final decision. And really that is an important leg of the Section 189 process. Consultation between employer and employee or employee's representative. And that is the crux of a retrenchment process. It really, from a procedural point of view, consultation is absolutely critical and vital. This requirement is essentially a formal or procedural one, but it has a substantive purpose. The purpose is to ensure that the ultimate decision on retrenchment is properly and genuinely justifiable by operational requirements, or put another way, by commercial or business rationale. Now, when are the provisions of Section 189 and 189 triggered? This is contained in Section 189(1), and when an employer contemplates, that's the wording used in the section, contemplates dismissing one or more employees for reasons based on employer's operational requirements. So when the possibility arises, that's when Section 189 or 189A, depending on the employees involved, is triggered. And once it's triggered, employers should follow that section as soon as possible. It's very difficult to follow it immediately. I mean, it could become a possibility at a very early stage, and therefore it should be followed, and the section should be triggered as soon as practically possible once it's contemplated, once retrenchment is contemplated. Okay, then just dealing with some basic terminology. This notion of contemplate has been considered by our courts. This is an oldish decision, 1995, and it was considered by the Appellate Division, which is now known as our Supreme Court of Appeal. And this is what the court had to say about the notion of contemplate. It seems to me that the duty to consult arises as a general rule, both in logic and in law, when an employer, having foreseen the need for it, contemplates retrenchment. So it suggests that it's a serious contemplation. It's not something that the chances of it materializing are very low. Once it's a serious and genuine contemplation, that's when immediately Section 189 should be triggered. And that's important to highlight here. The moment the possibility of retrenchment arises, that's when the duty to consult is born. And as soon as it becomes a possibility, this will trigger the duty to consult. Okay, just some other basic terms in a Section 189 context. A dismissal is quite obvious and quite clear. Now, you'll hear a lot of the term operational requirements. There is a definition in the Act, and it's defined as requirements based on the economic, technological, structural, or similar needs of an employer. So it's quite a wide definition, and one of the first slides we dealt with, touched upon each one. Economic is if the company wants to make more profits, and that has been upheld by courts that, if a company just wants to restructure in order to be more profitable, even if it is making a profit, that is fine. That is acceptable. It's not for our law or our courts to dictate to a business how to run its business. That's not the purpose of our labor law, and that's not the purpose of our courts. Therefore, if a company wants to become even more profitable than it already is, retrenchments can be invoked, and it's perfectly acceptable. Technological is quite clear and obvious. Machines replace employees, unfortunately, all the time. It's just one of those things, and that is recognized by our law and our courts. Structural as well. If we just want to restructure and reshape things, even if it doesn't necessarily lead to a profit, it might streamline things a bit easier. That's a valid basis to commence and embark upon retrenchments. And similar needs, that's quite an open and wide discretion given there, by legislation. Anything similar can be recognized as a valid basis to commence on retrenchments. So that's the actual definition of the word operational requirements, and you'll hear it quite a bit, especially in a 189 context. Okay, then moving on, just giving a high-level overview of the section. So Section 189 of the LRA, the term used is dismissal due to operational requirements. That will then trigger the employer's obligation to consult. There is a clearly defined set of subject matter which employer and employees must consult on. There's a Section 1893 notice which must be issued, and that notice is basically the agenda, if you will, for lack of a better word. It's an agenda to be followed. It's a prescribed agenda to be followed by employer and employee. And that's governed by the Section 1893 notice, which follows the actual section 189 sub 3. Employees must be given an opportunity to make representations. The employer is obliged to consider and respond to same. So in a very small nutshell, this is what 189 encapsulates. There must be a consultation on prescribed material. Employees must make representations, and the employer must consider them and respond to them. So there must be a joint, meaningful consensus-seeking process. And that's what Section 189 strives to achieve. And as we've said, 189A, it's the same process as the above. There's just other concepts that come into it, like facilitation, and we'll get there. We will get there near the end of the presentation. Okay, now starting with the general requirements for all retrenchments, both small and large scale. Who must be consulted? So this is an important first step. When an employer contemplates dismissing employees for operational requirements, the employer must consult. Now, Section 189A1 or Section 1891 has a prescribed list and hierarchy of who must be consulted. So the first one is any person whom the employer is required to consult in terms of a collective agreement. Now, I'm not sure how familiar everyone is with what a collective agreement is, and maybe at this point I can either pick on someone, or someone might want to raise their hand to venture an answer as to what a collective agreement is. Maybe just by chronological order, Adele Badenhorst, do you want to just venture a guess or an answer as to what is a collective agreement? Okay, I'm just seeing everyone's mics are muted. Maybe Adele or Basson van Eysen. Sorry guys, it's just checking. Sorry, is everyone still there? Okay. Yeah, sorry, I see a thumbs up from a Gideoni Briot. Sorry if I'm mispronouncing that. Gideon, maybe do you want to come in here and maybe we can discuss this concept of a collective agreement? Okay. So let me just see. Okay, Blaze, I'm not sure if anyone's allowed to interact, or I just see everyone's mics are muted, and I'm happy to just involve a bit more of a discussion with some of the attendees.
Right, that's right. People might just be a little bit shy to respond if they're not 100% sure of the answer. But
okay, no worries. Yeah. I just, if it's going to be me talking for 3 hours, it becomes a bit monotonous and tiring. So I don't know if where I can make it a discussion, I'd really, sorry, I'd really like to make it a bit more engaging. Apologies. Okay. Well then, that's fine. I'll continue. So what a collective agreement is, it's an agreement between employers and employees which regulates a particular industry. So for example, in the steel industry or manufacturing industry of particular products, or the car industry, one of the big ones is the Bargaining Council of MIBCO, so the motor industry. There are collective agreements which govern that industry, whether it is hairdressing or motor vehicles. So Blaze, I see your hands up. Oh, okay, it's gone down. Or Blaze, do you want to come in?
I think just there are a couple of responses. Van has sent through a comment in the chat. I don't know if you can see it on your side. So
the meeting
in response to your question earlier.
Sorry, on my side it says the meeting chat is muted. Settings. Should I click on settings?
If you just click on the chat pod, that's where you'll see Vanna sent through a response to your question.
Okay, let me. Sorry, somehow it was muted. Okay, so unmute. Save. Okay, I'm not sure why it's not allowing me. It says the meeting chat is muted, so unmute. Okay. For some reason, it's muted on my side, Blaze. I'm not sure why.
All right. In the meantime, let me just read through the comments. So Vanna responded: written contract negotiated through collective bargaining or employees by one or more trade unions with management of a company. That was in response to your question on.
Yes.
Okay.
It's a very formal definition, but yes, that is, often it's negotiated between employers' organizations on the one side and trade unions on the other side, because the trade unions represent the majority of employees in that particular industry. So NUMSA, I'm sure you've all heard of NUMSA. That's the National Union for Mine Workers. So they often represent the majority of employees in the mines and in the mining industry. So Yes, that definition is correct. And basically it's an agreement that governs a particular industry, and often that does deviate slightly from the Basic Conditions of Employment Act, but it also contains certain procedures which must be followed. And coming back to a Section 189 context, it may stipulate that the employers must consult, for example, the trade union. They must consult not the employees themselves, the trade union. So that's important to keep in mind. If there's no collective agreement, then consultation must happen through a workplace forum. They're not extremely common in South Africa, and they do exist. They exist more in your larger companies or certain particular industries. And also, so there's the workplace forum and any registered trade union who's likely to be affected. If there's no workplace forum, then it says it here in sub C, any registered trade union whose members are likely to be affected. And if there's no trade union or workplace forum or collective agreement, then you can consult with the employees themselves, the employees that are obviously issued with the 189 notices. However, even if the employees are not represented by a trade union, the employees can elect to be represented by, for example, a lawyer, an attorney or advocate, or any other representative nominated for that purpose. So where there's no trade union, it doesn't automatically mean it's the employees themselves. Employees can be legally represented by a lawyer or colleague or something to that effect, whoever they choose or nominate. So this is a hierarchy. It must be followed in this specific order. So if there is a collective agreement, you can't just skip and go to D and consult with the employees directly. You must follow this order and eliminate one by one until you eventually get to D, if none of the previous three exist. Okay, now what must be agreed? So we've dealt with who must be consulted. Now, in terms of Section 189, there is a prescribed list of the following that must be agreed upon between the consulting parties. So when you read subsections 1 and 3 together, there must be an engagement in a meaningful joint consensus-seeking process, and there must be an attempt to reach an agreement on. So the parties must try to reach consensus and agreement on the following 3 things. So this is A, this is just one. Appropriate measures to avoid the dismissals, to minimize the number of dismissals, to change the timing of the dismissals, and to mitigate the adverse effects of the dismissals. Now, I'm sure, as you can appreciate, this is not easily achieved and often is huge points of conjecture, because it's not always easy to get the employees to agree to this. Because obviously employees, risk losing their jobs, and employers want to retrench, for the reasons stated in their notice and for the reasons that they've embarked upon the process. So it's not always easy to achieve this. Then secondly, the method for selecting the employees to be dismissed. Now, the selection criteria is a very important aspect of a Section 189 process. And later on, and it's not too far down the line, I deal with various selection criteria which have been held to be acceptable by our courts. The classic one and the safest one is LIFO, last in, first out. So in other words, the employees with shorter periods of service or lengths of service should be retrenched, as opposed to those employees that have been there a long time. So LIFO is one example of a selection criteria, but it's important here to highlight that the consulting parties must reach agreement, on the selection criteria to be applied, because this will dictate who loses their jobs, quite literally. And there's various selection criteria that can be agreed upon. Then thirdly, the severance pay for dismissed employees. Now, if a company doesn't have a retrenchment policy, then the Section 40 1 of the BCEA will apply, and that is 1 week for every year of service. And it's important to highlight that it's for every completed year of service. So if someone's been employed for 3.5 years, they will only get 3 years of severance, which equates to 3 weeks of severance pay. It's often incorrectly applied because people either round up or take it literally as to how many months they've been employed. But it's important to highlight that it's completed years of service. So if it's 4+ years, you're only looking at 4 weeks. If it's 6+ years, 6 and a bit years, you're only looking at what's been completed years of service. Okay, now, sorry, I just see Bason is typing. So I'm just going to pause to see if there's a question. Okay, sorry, I can see the chat now. So does that mean a financial year or calendar year? It's calendar years. And it's not linked to the company's financial year. It's linked to the employee's length of service. So if someone joined in June of a particular year, it's every year thereafter. So if let's use the June example, you take it from 12 calendar months from June. Let's say it's June 2016. So if it's June 2016, and we take it to 21, it's 2017 is 1 year, June 2017 is 1 year, June 2018 is 2 years, June 2019 is 3 years, June 2020 is 4 years, and June 2021 would make it 5 years. So it's calendar years from the commencement of the employee's employment. Hope that answers the question. Then these are what we're going to deal with now is the mandatory items to be contained in the section 1893 notice. Apologies. So the items you're going to deal with are prescribed by section 1893 of the Labour Relations Act. And this must be what we're going to deal with here under must be contained in every single 1893 notice. So firstly, the reasons for the proposed dismissals. So often here we set out, and it's normally about a page. It's not just a sentence. We normally take up about a page when drafting for our clients, and we explain in great detail and in great length what the reasons are for the proposed dismissals. And it's obviously beneficial to the employees and the consulting parties to have a comprehensive understanding of why are we embarking upon a retrenchment procedure and a section 189 procedure. So it's advisable to be comprehensive here and set that out in great detail. The second one is a very important issue that's often very debatable, and it's quite a contentious topic during the consultations. The alternatives that the employer considered before proposing dismissals and the reasons for rejecting each of these alternatives. So in the notice, an employer must set out, I've considered these alternatives before embarking upon a retrenchment procedure, and I've rejected each of these alternatives for the following reasons. Because often, and it's a point which is required to be consulted on. Often the employees will say, but why are you doing it this way? Can you not do it that way? Instead of doing this and retrenching me, why don't you do this? So often this is a big bone of contention, and this must be dealt with in the notice itself. The alternatives considered and why they were rejected. Then C is just quite straightforward. It's just a piece of information, a piece of data, the number of employees likely to be affected, and the job categories in which they're employed. So, if it's, for example, one employee, it's quite straightforward, and you can just say it's one employee. But if it's a department or a group of employees, the notice must state we're looking at retrenching possibly 10 employees in this department, in X department. D, the employer in this notice must record the proposed method for selecting which employees to dismiss. As I said, things like LIFO. LIFO is a common one. There's others. There's skills, competence. There's many others that we'll go through. But the employer can at least propose a selection criteria and a selection method. Then the employees or the consulting parties can either agree to it or reject it and suggest different selection criteria. Then E, the time when or during the period during which the dismissals are likely to take effect. So what we do under this heading, we set out a timeline to be followed. So for example, we'll say, you issued your notice today. The next 2 weeks will be set aside for consultations. And we're going to have a consultation on Monday and next Friday, and then again on the following Wednesday, for example. Then we say, a period of reflection will take place. You can make representations if you wish. And then there's a deadline by which a decision will be made. So we actually set out a timeline. And in that timeline, it concludes with when the likely dismissals, if dismissals are unavoidable, when the dismissals will take effect. So it's a full timeline, which will help guide the parties during the consultation process. The severance pay proposed. Now, sometimes companies have a retrenchment policy where they offer 2 or 3 weeks severance pay, as opposed to the statutory minimum of 1 week. And it's perfectly permissible for a company to offer more severance pay. Section 41 in the BCA provides the minimum severance pay, which is 1 week for every completed calendar year of service. However, a company, an employer can pay more, and it might have a policy where it's 2, 3, possibly even 4 weeks severance pay for every completed calendar year of service. Then G is quite generic. Any assistance that the employer proposes to offer to employees likely to be dismissed. What we often include there is things like reference letters, time off to attend interviews. You want to try help the employees find another job as an employer. So we try to go the extra mile there. Remember, it's a no-fault dismissal. So it's not due to the employee's fault that he or she is getting dismissed. So it follows that the employer should try offer assistance where it can, using its laptop or computer equipment to apply for jobs, time off to attend interviews, reference letters, things like that. I mean, we even have some clients that offer, a bit of psychological support or, counseling, stuff like that, for them to go see a counselor or someone, if there is that benefit that the company offers, it can be offered during this time, because it's a very stressful time, obviously, for employees. The possibility of the future re-employment of the employees. So we also there we include a bit of a generic requirement, and we say after 6 months, you're welcome to start submitting your CV again. But often the possibility of future re-employment is very unlikely, but it can be, and it has to be dealt with in the notice. So we say after 6 months, you can approach the company again and see whether there is a vacancy. There's no hard and fast rule to any period. Also, the notice can say there is no possibility of future re-employment. That's fine. It can also say that we just often provide a period of 6 months where the employees can contact us and see if there is any position available for them. This is just a plain stat, the number of employees employed by the employer. Presumably this was included because it must be determined whether it's a large-scale retrenchment or a small-scale retrenchment. So that's just a piece of data that's inserted. And then J is also important, the number of employees that the employer has dismissed for operational requirements. In other words, the number of employees the employer has retrenched in the last 12 months. And there is a reason for this. because when looking at large-scale retrenchments, Section 189 capital A refers to, in other words, it includes the retrenched employees in the last 12 months. Therefore, if 10 or more employees were retrenched 6 months ago, and now we want to embark upon retrenching 2 more people, that will actually, the process for the other 2 people will be a large-scale retrenchment, because the company has already retrenched sufficient staff in the previous 12 months to render it a large-scale retrenchment. I hope that makes sense. Just let me know if you have any questions around that. We will touch on large-scale retrenchments a bit more down the line, but that's the reason it's included there, because it could constitute a large-scale retrenchment. Okay, now moving on, we deal with the concept of representations. The employer must allow the other consulting party or parties an opportunity during consultation to make representations about any matter, as well as any matter relating to proposed dismissals. So just to recap, if it's not clear as yet, the entire retrenchment process commences when the Section 1893 notice, so this notice, when this notice is issued to staff, that's when the process commences. Prior to then, we haven't started retrenchment yet. Once that notice is issued, which deals with all of these things, then the process has started. Thereafter, what must happen is there must be consultations between the employer and the consulting parties, for example, trade unions or the employees themselves. And during those consultations, the employer must allow the other consulting party to make representations, which can be made either verbally or in writing. There's a slide later on that deals with, if it's made in writing, the employer must respond in writing. So you can't just receive a letter and then respond verbally. It has to be like for like, written responses to written representations. Or if it's in a meeting, of course, it can be just done verbally. And our law requires that the employer must consider and respond to the representations made. And if the employer does not agree with them, the employer must state the reasons for disagreeing. And as I just said, if any representation is made in writing, the employer must respond in writing. So what our law requires is a visible procedure where representations are made and they must be responded to specifically. And if rejected, there must be reasons as to why they are rejected. So this concept of representations, it's an integral part of the consultation phase. And it goes to the heart of what a Section 189 process, entails. Then moving on, dealing with this issue of selection criteria, it's a very critical aspect of a Section 189 process. There have been many reported judgments where the selection criteria was held to be unfair, and that rendered the dismissals of the employees unfair. So it's not something that can be just passed on lightly. It must be, careful consideration must be given to what selection criteria is imposed and to be utilized during the process. So the employer must select the employees to be dismissed according to a particular selection criteria. Prize number one is that it's a selection criteria that is agreed to. So the consulting parties go, okay, we see there's a need to retrench, we accept that. Let's now choose a selection criteria which is fair and reasonable and which we can all agree on. So just practically speaking, say, for example, a notice is issued to 10 employees. It doesn't automatically mean that all 10 will be retrenched. It is possible, that any number of the 10, it's possible it could be 10, but it's possible it might be 5. The selection criteria utilized might dictate how many employees are ultimately retrenched. Therefore, it's incredibly critical to determine and try find by agreement, if possible, a selection criteria that is fair and reasonable to all parties. Now, if it cannot be agreed, then the employer has the onus to choose a selection criteria which is fair and objective. Now, obviously, that's not always easy to do, and it might lead to a debate as to what is objective, what is fair and objective. But the employer can only do so much, and it must try and pick a selection criteria which, at least in its mind, is fair and objective. And if challenged in a court of law, the employer can argue, well, it's fair and objective for these reasons. So yeah, that's how it proceeds on selection criteria, preferably by agreement, if not fair and objective. Now, our courts have held that the following selection criteria are acceptable. So there are reported judgments supporting each one of these selection criteria. As I said before, this is the number one selection criteria. Our courts love this. It's just the fairest. It makes logical sense. And our courts have always held that this is the most acceptable and fair selection criteria. Length of service, seniority, better known as LIFO. Last in, first out. It can involve with the retention of skills and or departmentally, but using it in the traditional sense is always preferred. However, you can try and combine it where if it's not strictly applied, we look at the criteria of the retention of skills. So for example, there might be a more junior employee that has a particular set of skills that the company wants to retain. And therefore, unfortunately, someone who has a longer length of service might ultimately be retrenched because the company does want to retain a certain set of skills, which is difficult to replace or for whatever reason. Moving on, competence and or merit. So in other words, to use an employee's performance. So this is obviously, this criteria blurs the lines a little bit. I'm not a big fan of it. I'm not in favor of it, but our courts have on occasion upheld it, that it was a fair selection criteria. So to look at, for example, performance reviews and performance scores over the last couple of years, and then the company can decide, well, out of these 10 employees, we're going to look at their performance over the last 2 years and select the ones who've performed well, and we'll retrench the ones that haven't performed well. I think it blurs the lines a little bit, between performance and retrenchment, but there are judgments which uphold this selection criteria. Skills and or experience. Now, as I briefly touched upon in the first selection criteria, the company may want to retain a certain set of skills or particular experience that an employee has for whatever reason, with a product, with a customer, with a client. So it may want to utilize this selection criteria to ensure that certain employees are ultimately retained. Qualifications or technical knowledge, I think it's very similar to the previous one. Conduct again. So conduct and service record. I mean, you can see these are all quite similar ultimately, and a combination of these can be used. Again, with conduct and service record, it does blur the lines a little bit, but as I've said, these are selection criteria which have been upheld by our courts, so our courts do accept them. I wouldn't automatically rely on these selection criteria to run a process. At the very worst, I would use a combination of these things, which has been done and which we often do, because it gives the employer some flexibility. You don't have to limit yourself just to one selection criteria. Some or all of these can be used, and there still are some other selection criteria on the next page, which I'm going to just deal with. Our courts have dealt with age. For example, and this is different to length of service, because someone who's 50 years old could have joined the company recently, versus someone who's 30 years old who's been there for 10 years. So age has been upheld. There's an old judgment to this effect, but in this day and age, and even the following one, age and gender, I think if there was a recent judgment to comment on these two, I think it could be criticized. I don't think this should be a selection criteria that should be frequently used. And I think because there's no recent judgment on these two, I think the employer would struggle to uphold that these two selection criteria, are fair and objective and reasonable. Now, I just want to spend a little bit more time on this notion of bumping. And I've left it there, and I've retracted. I'm just going to give anyone, I mean, if someone does want to just venture an answer, I'll wait about 30 seconds. You would have just briefly seen the word bumping. Does anyone want to venture an answer as to what is meant by the term bumping in a Section 189 context? And I'll just give it about 30 seconds. Okay, I'll carry on. It seems like everyone's a bit shy today. But guys, really, where you can and where you want to, please, ask me a question, engage with me where you can. It'll just make it, I think, a bit more interactive and engaging, obviously. So I'll carry on, Blaise. I see you typing, but I'll just carry on with the notion of bumping. Yes. In a nutshell, yes, it is that, but what the term is quite literal. And now let's say a particular person, so let's say there's a senior person. I think the example, because we can get vertical, horizontal, and triangular. The easiest example to explain to everyone is vertical. So vertical, up and down. Now, let's say we want to retrench potentially a CFO, in your line of work, someone who's a CFO. We're saying, you know what, we don't really need a CFO. We want to have a junior person run that position. We're looking at retrenching you. But there is a financial manager. There's a financial manager who occupies the position. Now, we could say to the CFO, okay, CFO, we want to retrench you, which is occupied by a person. But instead of retrenching you, we are going to ultimately retrench the financial manager. So we're going to bump that financial manager out, and then the CFO will fall into that financial manager's position. So it's a literal term of literally the employee who wasn't envisaged for retrenchment is bumped out. I hope that makes a bit of sense to you, in the sense of we weren't looking at retrenching a particular person, but in order to save that job, we are going to enforce bumping, and therefore other employees might have to be bumped out in order to avoid retrenchment going forward. So there is a bit of an explanation here. You see, instead of his or her employment being terminated, he or she may be transferred to another section to replace, bump other employees with shorter service who are then retrenched in terms of the LIFO formula. So I'm just seeing a question from Basson. Would it be acceptable to retain the right mix of employees to retain a certain BBBE level due to management demographics, which is necessary for the company to maintain certain contracts? In short, my answer to that is yes. I think that is a valid consideration to include as part of the selection criteria, and it has been done. So, what I would suggest there is that the BBBE level, or employment equity statistics, it's definitely a consideration to be included in the mix. So, you know, undoubtedly, yes, it can be used as a selection criteria. It can most certainly be used as a selection criteria. And in this day and age, it should be encouraged. It should be recommended that that should be at least one of these selection criteria that's thrown into the mix. Because, you know, that level and the BE level of a company is very critical for it to continue conducting business. So yes, Bason, it's definitely a valid selection criteria. Then I just deal with just very briefly. It sometimes happens that a particular company has multiple members of a family working for them. So if there's double income families, the selection of the wife, you know, or those families could be prioritized in order that, you know, the other employees could retain or save their jobs. So if a husband and wife are working for a company, we can target them first and retrench at least one of them, you know, because at least that household then won't be as badly affected as maybe other households. So this has been held to be a valid selection criteria. And then another method to try and avoid retrenchment is to have certain employees go on early retirement on a voluntary basis, which might save the jobs of other people. And then lastly, this also has been upheld by our courts, first in, first out, FIFO. It's also a valid selection criteria. It's not used that commonly, but it's also a selection criteria. So between this slide and the previous slide, you know, a combination of this can be used by an employer. And, you know, the trend seems to be going towards a combination of all of these, in the sense of, you know, we're looking at length of service, we're looking at skills, we're looking at qualifications, we're looking at experience, and the company will put that all together and then decide who will be retrenched when applying all of those factors. So yes, most certainly, I would use as many of these principles and these criteria as possible. Okay, then moving on, a different heading, just the notion of operational requirements. Okay, we dealt with this, so I'm just going to deal with it just briefly because the next slide is where I want to focus on. We've dealt with this definition, and you know, this is becoming more prevalent in this day and age. You know, when dismissals make business sense, there's a commercial rationale for it. Employers must assess the scope of the intended retrenchments in comparison to their operational objectives. So it's just repeating what I said near the beginning. If there's a commercial rationale and a purely business sense to embark upon a process, it's perfectly acceptable and lawful to do so. Now, the one that's slightly contentious, you know, but it has come before our courts, increasing profits. So as I briefly touched upon earlier, we're making a profit. We're not suffering, but we could restructure our business in such a way where we could make even more profit, and that's when the company embarks on a Section 189 process. Is that fair or is that unfair? Because, you know, a company is already making a profit, so why does it need to be greedy and make even more of a profit? So we're going to just deal with that a little bit. Okay. So our courts basically have held that a dismissal should not be regarded as unfair merely because the employer could objectively have afforded to retain all or some of retrenched employees. Okay. The Labour Appeal Court, our Labour Appeal Court, has held that the only requirement is a bona fide, that means good faith, economic rationale. The retrenchment must be aimed at affecting savings. And then there are these judgments which say, or to increase profits. Sorry, apologies for that typo. Or to increase profits. And that's what this decision has held before. So, and there's other decisions which say that as well. The Labour Appeal Court has held that employers are entitled to retrench in order to increase their profits rather than to avoid losses. There's two very well-known decisions that have confirmed that. And just in closing on this topic, our courts have held that, it's not for the law or the courts to decide or dictate to a business how to run its business. That would be quite restrictive if there were laws or if there were courts that said, you can't run your business like that. You have to run it this way. It's not for our legislature or our judiciary to run a business for companies. So companies are entitled to do that. What our law and what our courts try enforce upon everyone is that at least a fair procedure is followed. And that's why Section 189 and 189 capital A are so extensive, and they have a lot of requirements, and there's a lot of items that must be discussed. So yeah, I hope that resonates with everyone in the sense of, our law could never dictate how a business must be run. And our courts acknowledge this. They're well aware of this fact and they acknowledge it. And that's what it says here. The Labour Court, it will not intervene merely because it holds the view that another option could have been adopted. The judges can't pass their opinion and then enforce that onto a company. They're just hoping what they want is that a fair process and procedure is followed. Okay, I want to deal with this very briefly. I don't think it's entirely relevant to all of you here. There have been some judgments where a retrenchment has been invoked and the employees argue that, no, you're not really genuinely retrenching me. Rather, there's a Section 187(1)(c), which is an automatically unfair dismissal. And it renders, obviously, the dismissal automatically unfair. And not only that, employees are entitled to 24 months compensation as opposed to the ordinary 12 months compensation. And employees have argued in the past that the retrenchment wasn't a valid retrenchment, but rather it was a dismissal to compel the employee to accept a demand in respect of a matter of mutual interest. Now, this is a little bit technical, and I will try explain it to the best of my ability. So the two examples that are often used, that have often come up in our case law, is the employer will say, I need you to work more hours, or I need you to change your working hours and your working times, or I need you to accept a lower salary. So we haven't even gone into Section 189 yet. An employer just says, please, I need you to work on weekends, I need you to work longer hours, or I need you to take a salary cut. Then the employee says, no, I will not do that. And thereafter, the company embarks upon a Section 189 process. So this issue has come before our courts many times, and recently our courts held that, in essence, if there is a valid and genuine reason for retrenchment, then the employer won't fall foul of this section 187(1)(c), and it won't be enforcing an employee to accept a demand. That's the crux of the issue. It's a demand which the employer is forcing the employee to accept. But our courts say, if it's a genuine and valid retrenchment rationale and operational requirements, then it's not a demand that's being accepted, because you can also use a Section 189 process to lower someone's salary, in the sense of, you'll issue them with a Section 189 notice, and one of the alternatives suggested is, what, don't retrench me. Why don't you just cut my salary by 20%? And that might avoid my retrenchment. So that process and the whole process can be used to change an employee's terms and conditions of employment. But the important difference is that it's done by agreement with the employee. So the employee agrees, fine, I don't want to lose my job. Rather than losing my job, I'll take a salary cut of 20 or 25% or whatever percentage it is. So, and that is not a demand which is being forced upon an employee. So it is quite a technical issue, this, and it's baffled our courts for many years, and our Labour Appeal Court has given a judgment about 2 years ago on this issue. And in short, what it held is, if there's a valid and genuine bona fide operational reason for the Section 189, that's fine. However, if the Section 189 process is being abused by employers in order to, force employees to accept a demand in respect of any matter of mutual interest between them, then you risk having an automatically unfair dismissal. And a matter of mutual interest is basically anything regarding employment. It's salary, it's working time, it's lunch hour. It's basically anything that is of a matter of mutual interest between an employer and an employee. So yeah, I might just pause. I don't know if anyone might have a question around this, because the wording is a bit foreign and it's not always easy to understand. But yeah, I've tried to summarize it best I can. And in short, what you can take away from this issue is that Section 189 processes should not be abused by employers. And if they are abused, and if they are being used for an ulterior motive to try get a lower salary or change an employee's working hours, if that's the sole goal, then there's a risk of an automatically unfair dismissal coming into play. Okay, just moving on then. Okay, I'm just going to pause. I see, so there is a question coming through from Bason.
Sorry, where actually the 187 is, you don't want to, or you're not acting in good faith in terms of under 189. So it's almost like a prevention clause of to prevent one acting in not in good faith.
Exactly. If it's used with an ulterior motive, let's say, the employer says, I don't want to fire anyone, I don't want to retrench anyone, but I'm going to issue them with 189 notices in bad faith to try lower their salaries, because I want to lower their salaries, because I want them to work on weekends, because I want them to no longer have lunch hours. Then the employer risks, and then the employees say, no, we're not agreeing to that. We're not working on weekends. We're not taking a salary cut. Then the employer dismisses them, retrenches them. The employees then refer an automatically unfair dismissal. So yes, Louise, it's exactly for those reasons, when it's used in a bad faith or male fide context. I see. Okay, I'm going to move on. I see, Bason, you're typing something, but I don't think it's come through. So I'll just move on. Okay. So I just want to touch on these two concepts a little bit, and I did right at the beginning briefly. In order for any dismissal in our law to be fair, it must be substantively fair. Substantive means it must have a fair reason. There must be a good reason or rationale or basis for a dismissal. And then it must also be procedurally fair. There must just be a process. If it's misconduct, you must have committed a misconduct like theft, and you must have had a hearing. In a 189 context, there must be operational requirements that justify it, and we must follow a Section 189 process where there's a notice issued and there's a period of consultation. And there's an interplay between the two in a Section 189 process, because they should occur in an ideal world simultaneously. And a decision to just reference to this judgment, Johnson & Johnson, an LAC decision. The decision to retrench must be rationally justifiable. The question is not simply whether the employer acted in good faith, namely whether there was a bona fide reason for retrenchment. Rather, the inquiry goes further to determine whether the employer, on a balance of probability, is able to prove the cause of the retrenchment was a genuine operational requirement and the procedure followed was in accordance with Section 189. Okay, so I think that's just a summary of everything I've touched upon thus far. It's got to be a genuine operational requirement, and it can't be sort of made up or manufactured, just because the employer is trying to be a bit crafty. As long as it can be a genuine operational requirement, then our law and our courts won't have an issue. And then obviously the procedure is critical in a Section 189 process. Otherwise, the dismissal will be unfair. Okay. Just briefly again, no fault dismissals. It's important to highlight this. Employers may accordingly not retrench employees in an attempt to rid themselves of employees who are performing poorly. So again, it does sometimes happen that employers are faced with difficult or employees they don't want, and they go, how can I get rid of this person? Should I try get them on misconduct? Should I do performance, or should I just go with retrenchment because that's just easy to do? But if that process ever gets challenged, our courts will try to look through that and see, is this a genuine operational requirement dismissal? Or was an employer just using this process to get rid of employees it didn't want? Now, obviously, Section 189 must not be used for an employer just to get rid of employees it doesn't want. That is not the purpose of the section. That is not what it's intended for. And if that happens, the dismissals will obviously be held to be unfair. Similarly, with disciplinary action, you can't use retrenchment proceedings as a substitute for disciplinary action. If someone's committed misconduct, or if they've been committing misconduct for a while, that's the process that must be followed, and not a Section 189 process. And then there's just reference to a case that we've put in here, Fawu on behalf of Kapesi. The Labour Court has held that it would be permissible for an employer to retrench, but only when it is impossible to follow the normal disciplinary route when the dismissal indeed serves an operational requirement. Okay, so the reason we've put this in here is because this was quite an interesting judgment, and it does slightly go against everything contained in the LRA. What this judgment held here is that in a very unique and exceptional circumstance, you can retrench, but only when it is impossible to follow the normal disciplinary route when the dismissal indeed serves an operational requirement. So there are some examples that have come into effect. So the one famous example is where an employee has been arrested and has gone to jail, and the company cannot run a process while the employee is in jail. So given that unique set of circumstances, the company has to render the role redundant and can retrench the employee if it's virtually impossible to follow a normal disciplinary section. Look, this doesn't often come up, but where an employer can show that it is virtually and practically impossible to follow a disciplinary hearing for whatever reason, and the one example I'm aware of is when employees in jail, they can then retrench that employee because there's no other way. They render the role redundant because there's no other way to dismiss. That's very rare. It doesn't come up every now and again, but we've just included it in the slides because it's a bit more interesting, and it's not your norm. And there is a condition that was inserted here by the court. Okay, now we're just going to deal with this important requirement of the duty to consult. It's an important leg of any Section 189 process. Okay, so it's triggered once retrenchments are contemplated. And as I said earlier, this process commences when an employer issues a notice in terms of Section 189.3. Before this notice is issued, the process has not started. Everything starts when this notice is issued. Now, sometimes, and this is just a personal preference, a personal choice, employers consult when the notice is issued, so on the same day. So they kill two birds with one stone. They give the notice and then they immediately embark upon a first consultation. However, the more likely trend and the preferred trend or the recommended trend is you issue the notice and you arrange a consultation, a couple of days or a week or two thereafter, because the employees need a little bit of time to digest what's in the notice and go through it. Sometimes these notices are 5 or 6 pages and there's a lot of items that are discussed therein, and contained therein. So they need some time to process it and go through it so that you can have a meaningful joint consensus seeking process. And this is the terminology used in the section. It's meant to be a joint process. It's bilateral. It must involve multiple parties. It's not one party dictating to the other. Where possible, you must try reach agreement on every aspect of the 189 process. It's not always easy to do, but that is the goal, and that's what our legislature, is intending through this section. It's a two-way street. I'm going to briefly just remind you again, there must be an opportunity to suggest, ways to minimize the effects of the proposed retrenchments. There's many ways, there's many alternatives that one can suggest, and almost in every single retrenchment process, there's always ways that you can come up with an alternative. Salary cuts, a restructure, there's many other ways that retrenchments can be avoided. So this often comes up, and all the employer must do is at least say, I've considered it, I've listened to it, it doesn't work for this reason, or hey, that's actually a good suggestion. We can actually avoid a few retrenchments doing that. So employers should avoid a mechanical checklist approach. And this does often happen because, a retrenchment must never be a foregone conclusion. That's the opposite of what our law requires. It must be a consultation. It must be a process. It must be, look, the business has these challenges, and we're thinking about retrenching you. What do you have to say? What do you have any ideas? Do you have any suggestions? Do you have any alternatives? If an employer just goes, we're doing this, I'm just literally ticking the boxes, and I'm not going to listen to what you have to say, that dismissal could be held to be unfair. So we want to avoid any mechanical checklist approach to the consultation process, because that could be unlawful. It's all about seeking consensus, and you do that through consultation and engaging with employees. It's a joint problem solving. That's a nice word there. It's a problem solving process, and if you can't solve the problem, then retrenchment is a last resort. And as I've said, we must try to reach agreement where possible. The courts will consider whether the time taken to consult was sufficient in order to determine whether the consultation was meaningful. So on that last point, you can't rush the process. Employers can't say, we're issuing with the notice today, we'll consult tomorrow, and then we'll make a decision on Friday type thing. The process must take as long as it needs. It cannot be rushed, because if it's rushed, objectively rushed, then employers risk it being, the dismissals, any retrenchments being held to be unfair and unlawful. Yeah, so just on this slide, we want to highlight that a consultation doesn't necessarily mean negotiation, in that it doesn't have to be a back and forth and a proposal and counter proposal. Consultation means I've heard you, I agree here, I don't agree here. There's a fine line, but there is a distinction which must be highlighted. It doesn't mean we have to reach an agreement. Consultation means I'm giving you an opportunity to be heard. Make your representations. I'll consider them, and I'll accept or reject them for these reasons. And in this judgment, it's an old judgment, but it's good to highlight and remember it. Consultation means to take counsel or seek information or advice from someone, and does not imply any kind of agreement. Negotiation means to confer with a view to compromise and agreement. So there is a fine line there, and it may be blurry, but all the court was trying to highlight there is give the employees an opportunity to be heard and make representations. You don't have to agree to them, but consult with the employees and give them that voice. And it doesn't mean you have to negotiate and reach an agreement. So there is a distinction there which is worth highlighting. And we must obviously seriously consider any proposals made by the employees. And then lastly, on this slide, there's a judgment by Labour Court, Satawu v. Roadway Logistics, that says consultation will not necessarily be held to be a mere pretense if the employer approaches the matter predisposed to a particular solution. So, the test is whether management retained a mind sufficiently open to be persuaded. Again, this just speaks to it mustn't be a fait accompli. It mustn't be a foregone conclusion where the employer approaches this going, you're going to lose your job and I'm just listening to you for the sake of listening to you. That obviously is not going to be good, and the employer risks the dismissals being unfair and unlawful. Okay, carrying on just on this principle, consultation is not a one-sided process. It must be two-sided, bilateral. And then just on this point, Nahawu v. University of Fort Hare, it does sometimes happen that employees will employ delay tactics. They'll be sick, they'll not make meetings, they won't want to engage in the consultation process. And, clearly because they're trying to avoid losing their job and they're trying to prolong sometimes what is, the inevitable, but it's not always clear. But employees ultimately try evade or delay consultations. And, this is not foreign, and our courts have considered it. So where this happens, our courts have held that employees will be precluded from relying on the absence of consultations. So in other words, they can't complain that the company didn't follow a consultation process. If at least the employer can show they tried everything within their power to consult, but the employees frustrated the process. And in this case, the trade unions kept changing the goalposts, which was aimed at nothing more than dragging out the process. So if, on the other hand, the employees or the trade unions are acting in bad faith and they are not genuinely engaging in the consultation, then the employer can proceed with the dismissal, and then it can argue, well, they were frustrating the process. They weren't, coming to the party. So our courts are alive to this, and it's nice to know that there is case law to say, it's the employees can also be at fault here. If they are not engaging in the consultation process, then the employer need not have one because they're not engaging. So it's good to keep that in mind. Obviously, even when that happens, though, the employer must have a record and must at least be able to show to the court, well, look, I tried to have this meeting. I phoned, this person 10 times and they didn't answer. At least have a record to show the attempts made to consult, because you can't just quickly say, well, they're frustrating it, they're not trying, and I'm going to dismiss you. And this just concludes in rushing the consultation process may lead to the conclusion that the employer's actions are insensitive and subsequently lead to a finding of procedural unfairness. So it's you've got to put all of these considerations together and just ultimately ensure that it's a fair process and follow the letter of the law to the best of one's ability. And if we rush it, we might risk having an unfair retrenchment. Okay, I'm going to just quickly go through the slide because I do have a lot of slides to go through. I think we've touched upon this. We've touched upon this, and there's just some other judgments that I'll briefly, there's this word fait accompli. It just means foregone conclusion. And obviously you must retrench before, you must consult. Consult must commence before the decision to retrench. The test to determine when the employer has contemplated retrenchment or not is objective. All it's trying to highlight there is that the need to consult and the need to retrench is always done objectively, because the opposite is subjectively, and there may be occasions where the subjectivity of an employer is unfair, because an employer might either say it's too early to retrench when it's not too early. It actually should have been done many months ago. Or it's too late to retrench. So where possible, that question should be answered objectively speaking. And objectively is just what would the reasonable person conclude? Not always easy, of course, but that decision and that test must always be done objectively where possible. Okay. Just the consulting parties, the notice must be issued, as we said, recorded in any collective agreement, trade union. This is just another way in which we've done the hierarchy. It must follow this process. And there's a hierarchy of consulting parties. Okay, we've touched upon that. So now the retrenchment notice. The employees or their representatives should be informed as soon as possible. And the notice should contain the necessary information to enable the parties to make suggestions. So we've touched upon it. It must contain all of these things. It's mandatory that it contains all of these things. And we're just going to deal with some of them now going forward. Okay. Okay. I think we've dealt with all of this, guys. I want to just get into some of the headings in the notice. I think that's quite straightforward. Just here, it mustn't always just be a verbatim, recitation of the provisions of Section 189. You must apply the facts of any particular retrenchment to a particular process. Okay. Then just a point here we raise, often a company consists of different divisions which are differently affected by the company's operational requirements. Then the company need not necessarily wait until consultations are completed in each division before retrenchments are embarked upon. Just here, all I want to highlight here is that, if a company issues a notice to, let's say, 10 employees, the company will consult with them individually, and you may, because there's 10 different consultations going on at the same time, the process might be concluded earlier in respect of some employees as opposed to later with others. And where that's done, there's nothing wrong in employees saying, okay, well, we've reached the stage with you. Unfortunately, we haven't found any alternatives. The process is now finished, and we can now proceed with a retrenchment. So all that's worth highlighting here is that a company need not be, hamstrung and wait until the consultation is finished with all employees. In an ideal world, that's what should happen. But where that's not possible, or where that doesn't happen, it's perfectly fine. It's perfectly acceptable for an employer to proceed with a retrenchment in respect of those employees, and then retrench where that process has ended. So it's worth just highlighting that and keeping that in mind. So I'm going to move on to a new section now. I see it's 10:25. So I don't know, I think now would probably be a convenient time just to take a, Blaze, I think we said 15 minutes. A 15-minute break. And if we could just come back at 20 to 11. So we can take a 15-minute break, and I'm happy to, if anyone has questions, to maybe just deal with any questions at the start of that session. Otherwise, yeah, let's come back in 15 minutes at 20 to 11. And if anyone has questions, I'm happy to deal with them. Thanks, guys. Okay, welcome back, everyone. 20 to 11. I've got about 45 minutes left of the session, give or take a few minutes. So yeah, I'm going to proceed. Just please let me know if anyone has any questions at this stage. And I'll try in the next session just involve a few more examples and give you guys a chance to apply and answer a few questions. Okay, so yeah, we're just going to deal with the topics for consultation. Okay, now one of the interesting topics is appropriate measures to avoid dismissal. Now, as it says there, whilst the employer has the right to decide on the operational requirements of its business, employees may challenge the necessity to retrench. And that often happens. I mean, especially with the large scale retrenchments like your SABCs and your post office. People challenge the retrenchments, and they don't just accept it lying down. So employees may, of course, propose measures which may save their jobs. These are just some examples, but the list is almost limitless. Freeze on new hires, implementing short time. That is quite a common one. I mean, depending on the industry, often that applies in sort of, manufacturing or factory based workers. That often does work and is often applied as an alternative. The transfer of employees to different branches, voluntary retirements, which we discussed briefly earlier, because that could help alleviate the need to retrench other staff if certain of the elderly staff, choose to retire, and the non-renewal of fixed-term contracts. Those are really just some examples. It's difficult to put it down in a list because it depends on the facts, the reasons for the retrenchment, and stuff like that. Then the retrenchment will be fair if the employer has considered such proposals and can explain why they are not feasible. There is a high onus on an employer because it need not only just receive and consider an alternative, it actually needs to say, this alternative will not work because of X, Y, and Z. So you can't just say, an employer can't just say, I reject that alternative, it's not going to work. You need to say, why is it not going to work? There's actually an onus on an employer to reject a proposal with reasons and not just reject it. This is also a key topic because we can also try minimize the number of dismissals. So, earlier it's to avoid dismissals altogether, but there could be measures to avoid the number of dismissals. Instead of 10, we could make it 1. The most common one here is always, well, why don't you just retrench the guy that earns the most money and the rest of us will be fine? So that often, comes up, but often the response is, but we need that person. He's got a particular set of skills, experience, knowledge, industry knowledge, but in certain cases, that might work. You might go, well, let's retrench the CEO, for example, just an example, and then the rest of the employees can keep their jobs. So it is something that must be considered. Also this, changing the timing of the dismissals, this can, depending on the employees and the environment, it can play a role, and it's not a trivial issue. If an employee can get an extra month of employment and an extra salary, that will help. And, and that will be considered fair. And it also shows the employer accommodating the employees. So that must also be consulted on. Can we change the timing of the dismissals? Because in the notice, there is a proposed date of the retrenchment. It is in the timing. So if that can be moved out, that will help, and that will at least shed the employer in a good light and make the process seem a lot fairer. Then we also need to come up with measures to mitigate the adverse effects of the dismissals. This is, again, I listed some examples earlier, but these are some examples that are often inserted in the notices. Assisting with drafting CVs, reasonable time off to attend interviews, counseling and training. You know, there's no harm in doing that, and it should be encouraged, because as we've said many times, it's a no-fault dismissal. So employers need to try mitigate the adverse effects of the dismissals, and a reference letter also goes a long way. There's no strict obligation on the employer to do it, but obviously it should, you know, where possible, it should be done. Okay, the method of selection. This is hotly debated, and I've been involved in many matters where this is the area attacked by the employees, because this can dictate who gets retrenched and who keeps a job. So this is massive. And as I say, the trend nowadays to be safe and to do sort of an all-encompassing approach is to do a combination of selection criteria, and not just have one. But if you're going to go with one, LIFO is king. Severance pay must be, you know, discussed, as we said, at least 1 week for every completed year of calendar service. They can make a counter proposal. You know, you can agree more than 1 week to try help, you know, the employee and help the situation and make the process a bit more smoother. But there's no obligation on an employer to agree on more than the minimum prescribed severance pay. Okay, now what we've done here is we've just shown some do's and don'ts during consultation. So let me start with the don'ts. I mean, it's a bit more interesting, and this is what should not be done. All the terminology and wording should not always refer to new structure, because anything like that suggests, well, the decision has been taken and this will be implemented. However, we always try to highlight in the notices and to clients, this is a proposal. No final decisions have yet been taken, because nothing can be implemented which may possibly lead to a retrenchment without first following a 189 process. Let me just repeat that and highlight that a little bit. An employer cannot take any decisions that might lead to possible retrenchments without first following a 189 process. So even if no job losses, you know, eventuate, even if there are no job losses, you must still follow a 189 process, because the possibility exists that employees might lose their jobs due to retrenchment. So all of the talk must be about, this is a proposal, it's a possibility, it's a proposed new structure, it's a possible new thing we're going to do. No final decisions have yet been taken. Also, where we try to do it, what we strongly suggest and recommend to clients is that they don't talk about individuals. You know, where possible, we're not retrenching people, rather it's about the roles are being affected. It's the person occupying the role versus the person themselves. You may think it's an artificial distinction, but it's really not. We are more concerned with the job, the title, the role, not the person that occupies the role. So it takes the personal nature out of it. It takes the human element out of it. We're not focused on human beings. We're focused on the jobs, the roles, the structures. And unfortunately, as a consequence, the people that occupy those roles are the affected employees. So I hope that makes sense. But it normally works well that you try not personalize it. In fact, you do it the opposite. You say it's the role that's being affected, not you. Remember, it's a no-fault dismissal. It's always advisable not to respond immediately to proposals, and this is because often, and I will say often, you know, employees make some good proposals that need some reflection, that need some time and consideration, and the employers must take time to formulate considered responses and not just reject proposals out of turn, you know, immediately as they receive them. So it's a huge don't to reply to a proposal immediately, because that might come back to bite employers, further down the line. And then don't make any promises that an employer cannot fulfill. That's quite logical. It's quite general. It must never be a case of, we'll try our best not for you to get retrenched. We'll try our best that you don't lose your job. That's really a slippery slope and asking for problems. As for the do's, I'll go through these fairly quickly. Obviously, the consultation must be meaningful. Employers must keep an open mind. If there's a closed mind to the consultation and the entire process, there's a risk of the dismissal being unfair. The impression must be created, truthfully or not, the impression must be created in the mind of the employees that the company is open to and will consider alternatives, and that nothing is set in stone. It mustn't be a case of it's a foregone conclusion and this is how it's going to be. There must be a discussion and consideration of viable alternatives. We also tell our clients that they must assume that their discussions are recorded without their knowledge or consent. So in terms of the RICA Act, Section 4 of the RICA Act, a person can record conversations that they are a party to. It's illegal to record conversations that you are not a party to, but you can record discussions and conversations without your knowledge or permission or consent. So especially in these sorts of consultations, just act as if you're being recorded. It's always just a good general consideration to have in anything you do, because you could be recorded at any time. Sorry. And then, as I said, right at the beginning or near the beginning, where a representation is made in writing, the company must respond in writing. So that is a strict requirement in terms of our law. And if we can't show any responses in writing, then we risk, there's a bit of risk there, because that is a requirement. Okay, moving on. Those are just some general do's and don'ts during consultation. So what we've prepared is a little bit of a case study. I don't know where I can involve all of you, but it's meant to be a practical example, and I'll try and involve you where I can. W.consulting realizes that its present operating business model is not sufficiently streamlined or efficient. W.consulting wants to adopt a structure that will give it a competitive edge. What kind of wording should go in the notice? Okay, so what we're going to discuss now is particular wording. I mean, we do these quite a lot. It's quite sad to say, and it's unfortunate, but we do a lot of these notices for a lot of our clients. So we've got some wording we're going to go through. I don't know if anyone here has got any experience in actually drafting a notice. If you do, you're welcome to just discuss this with me, because I'm not sure to what level any of you have actually drafted a notice, but we're going to go through some of the typical wording you'll see in these notices. Okay, so we get to the rationale. So this is the verbatim wording we would use in the Section 189 notice. And I'm just going to read it out for everyone's benefit, but it's nice wording it's nice verbiage to just get everyone to see sort of the rationale, the typical rationale used. Due to the operational requirements of W.consulting defined as the company, the need to improve efficiencies and effectiveness and to reduce costs where possible, the company is considering, and I just pause there to highlight how it's merely a consideration. It's a proposal. We haven't made any final decisions. Nothing's been implemented. A restructuring of its various business operations and divisions across the company. That's just the opening paragraph. Okay, sorry, Computer's doing something funny, and then, okay, there. I'm just trying to go to the next. Okay, this is quite a mouthful. I'm not going to read it all, but I'll just highlight certain sections of this. Okay, we believe that the proposed new structure, so we will present to the employees a new structure. Now, what I personally like to do, and it's not here in this specific example, but it's always nice to have a organogram. So an organogram of the old structure and then organogram of the new structure. And ideally, the old organogram will have lots of blocks and lots of lines going in all sorts of directions. And then the new organogram is going to be a lot simpler. That's the easiest way to demonstrate, or at least show to the employees, a visualization of the old structure and the new structure. And again, the structure will, among other things, reduce costs, gain efficiencies, remove unnecessary roles or duplication in roles, improve upon job responsibilities and accountability, and streamline the organization to meet increasingly competitive pressures. So again, these are just descriptions we've come up with over the years to try and demonstrate how we are trying to streamline operations. We are trying to remove the clutter, and unfortunately, as part of this process, it's a commercial reality. It's a sad commercial reality, but certain people might get retrenched. What I just want to highlight here is the wording and the way it's still a possibility. It's not a foregone conclusion. No decisions have been made. Should the proposed new structure be implemented, your current position in the company may be affected. Again, it's a possibility. It's not a foregone conclusion. And in this paragraph, it just says, where redundancies appear unavoidable, this will result in a retrenchment. You know, we do have to say to the employees that it is possible. It is possible that if it's unavoidable, you know, you could be retrenched. So we envisage implementing the proposed new structure during November 2021. So already there, you can see that this is not the timeline, by the way, that we discussed earlier. It's just right at the beginning. It's saying, well, we are envisaging doing this new structure in November. So we've got, I mean, if now it's June, we've got 4 or 5 odd months. I mean, that could be a bit sooner. It could be later, whatever is reasonable. But we're giving the employees a clear indication of when this new structure is possibly, it's not yet implemented, is possibly going to be implemented. However, we underline here, no final decisions have yet been made, as we first wish to consult with you, managers and other stakeholders, to ensure that, among other things, you are fully aware of the process, the proposed model, the rationale behind the model, and the options available to you. So I think this paragraph captures quite nicely how this is, it's a joint process. We haven't taken a decision yet. We want to involve you in the decision. We want to just show you the risks and the possibilities of what this new structure will entail if it's implemented. You know, we're playing open cards, we're being transparent, and we're involving you. So we're going to go on to the next slide. It carries on, but this is, I hope you guys are appreciating how it's coming across from the company to the employees. It's very fair, it's open, it's not their fault, and we're involving them. Okay, it's another similar wording. It could be included, or it could replace some of the previous paragraphs. You know, we say to compete effectively. That's an economic reason. It's not technological, and it borders on structural. In this regard, the company's current structure appears to be unnecessarily cumbersome, consists of unnecessary duplicate roles, and as well as several similar related functions which will be inappropriately decentralized across the company. Okay. These factors unfortunately prove to be an impediment to efficient business operation, production, and our ability to compete. The company has embarked upon a careful analysis and investigation of the structure to identify shortcomings. The company's ultimate objective is to reduce costs and to create a simpler, more effective, cohesive structure in order to maximize efficiency, sales, and profit. So we just wanted to give you this wording because it really does capture the practical reality and the commercial reality of how retrenchments happen in this day and age. This is the wording we put in our notices. This is the cover page. This is the first page, and it already, it paints the picture for employees, and it shows them, and we're telling them openly and honestly, this is why we're doing it, and there's a commercial basis and reason to do it. And the company cannot be faulted if it does it this way. And you can see already it's comprehensive. It's not just a one-liner or a two-liner. And we're trying to give the employees as much information as possible. Okay. Then moving on, this is still example of some wording, and these are now dealing with the alternatives considered. So as I've said a few times, I think, in the notice, we must deal with this. And this is the wording we put, the alternatives considered by the company. Such measures included our having. These are now alternatives that the company's considered and which we say are not viable. Reduce the number of new hires and allocated responsibilities to existing team members. Minimize the number of external recruitments by promoting within the company where possible. Limited business expense to essential items and only expense claims essential for driving business performance approved. Enforced processes of managing individual performance. Held off on hiring in certain areas where current vacancies exist. And then you can list, these are some examples, as I say, this is just wording. And we end off by saying the gains achieved with the implementation of these measures have been insufficient. So we're saying we've tried these alternatives. Not only have we considered them, we've actually implemented them, and still we're not getting a saving that we want. We still want to be more efficient. We want to be more profitable. And in the company's opinion, the new model will offer a better solution than these alternatives could or have. And we nonetheless invite you to make representations and proposals on any and all alternatives to the implementation of the proposed new structure, which we will obviously consider and further explore with you. So we list the alternatives we've considered, but we invite the employees to make their own proposals because they may have their own ideas and own alternatives separate to these 5 that we've put in there. So we must still give them an opportunity to make their own proposals on the alternatives. Okay. Moving on now. Now we're dealing with the selection criteria, and this is wording that we often put in our notices. Should we, after consultation with you, elect to proceed with the implementation of the proposed new structure, we propose applying the following selection criteria. Now, this is quite lengthy, what you're going to see, and it's a combination. It's a combination of the factors we discussed earlier. So there's here, my favorite, a new organogram. So there'll be a new organogram of the new structure. Now, what we've done, what we're doing a lot now, and recent case law has upheld this. Often what happens is you apply a fair and equitable job recruitment process. So in terms of this process, employees can apply. So they will be required to apply for one or more of the positions within the new organogram, within the proposed new structure, based on their skills, qualifications, and work experience. So because with the old structure, maybe there were 10 positions or 10 employees, but now you have a new structure where there's only 5 available positions. Now these 10 employees have to apply for whichever position they think they are best suited for. And then the company can hire, from the 10, the 5 that are most suitable for those 5 positions. And there's a bit of flexibility there. The company can put forward a person for a particular position if they haven't applied, or an employee can, apply for any position they think they're suited for. Once we've filled those 5 positions, then unfortunately the remaining 5, will be retrenched. So this is one that we are, deploying a lot and that our clients like, because it gives a bit of flexibility. Here I just say that 4th bullet point, your name may be put forward by the company for consideration. There's interviews. There's a proper interview process and a job recruitment process. And for those applicants who are unsuccessful, the retrenchment process will continue, and such persons should persist, but ultimately, they may be, unfortunately, retrenched if they're unsuccessful to fit in any position. So this is just an example, and this is the verbatim, verbiage that we use in our notices. And you can see it's a combination of a few selection criteria. Not sure if there's any questions on this, because I think it's quite interesting and it's a combination, but if there are, just please let me know. And I'll see your question in the comments. Okay, so we're just going to move on, dealing with now representations and the duty to consider same. Okay, all I want to highlight on this slide before I move on, because the next topic is large-scale retrenchments. Our courts have criticized, and these are the words they used, either box ticking or mere lip service approach. We cannot just do lip service to the section. There must be genuine and actual representation and responses thereto. And employers must keep an open mind during this process, and they must be open to representations, meaningfully consider them, and respond. Okay, I think we've touched upon this at length, and I think that's come across. We're now just going to move to large-scale retrenchments, section 189, capital A of the LRA. Now, there is a sliding scale that is applied to see if this section is triggered. Okay, so firstly, the starting point is there must be at least 50 employees. Okay, therefore, if there's less than 50 employees, we won't even get to this section. Never mind if let's say, for example, there's 40 employees and the company wants to retrench 30. It's still a small scale retrenchment. It's not a large scale retrenchment. So the starting point is there must be more than 50 employees. Okay, that's the starting point. And so there's now we have a sliding scale. The employer contemplates dismissing by reason of operation requirements at least 10 employees if the employer employs up to 200 employees. 20 employees if the employer employs 200 to 300. 30 if the employer employs 300 to 400. 40 if the employer employs 400 to 500, and 50 if the employer employs more than 400 employees. So there is that scale, and this helps guide whether section 189A is triggered or not. Okay, there's one more qualification to the scale, and I touched upon it earlier. Or the number of employees that the employer contemplated dismissing together, I highlight together, with the number of employees that have been dismissed, that have been retrenched in the 12 months, is equal to or exceeds the relevant number specified in the preceding subparagraph. So I hope that makes sense. If, for example, an employer has retrenched 20 employees in the preceding 12 months, and then, 6 months later or at the time, it wants to retrench one person, just one person, that will be a large-scale retrenchment, because they've retrenched, more than the 10, 20, or 30 in the preceding 12 months. So they've retrenched enough to fall within this area, even though currently, within a 12-month period, they're only retrenching one person. Okay, I hope that makes sense. Please let me know if you have any questions. If I may, just to give a verbal example, and I'll ask, even in the comment section, if you guys are welcome to answer. Now, will it be, and you guys just have to listen carefully, will it be a large-scale retrenchment or a small-scale retrenchment if an employer employs 55 people? Okay, it employs 55 people, and it's now seeking to retrench. It employs 55, so it's under the 200 mark, and it's now seeking to retrench 22 people. 22 out of 55. So it doesn't fall under there. It's not, they don't employ 200 to 300 people. They employ 55 people. Will it be a large scale or a small scale retrenchment? Even though they don't, and they're not looking at 20 employees. They're looking at, well, let's say, sorry, if I can just say it's 15 employees. So they don't fall within here. 20 employees if the employer employs 200 to 300. They're looking at retrenching 15. Apologies for that. So I see Louise is typing, even though they won't fall here. Yes, it still will be large scale. We have had, a few people have been confused because they wanted to fall specifically in these sections. In other words, if it has to get to 20 employees and you have to employ 200 to 300. But no, Louise, you're correct. It's large scale, because even if you don't fall within those sections, if you're this is the key number here. If you're looking at least 10 employees, so if you're looking at 15 and you employ 60, 70, 80, it will be large scale. So the important number is this one on the left, not so much that one. But you must consider it carefully and look at it whether you're looking at 10 or more, 20, 30, 40, 50, but it's easier to just look at this number on the left to see if it's a large scale or small scale. I hope that makes sense. So one of the big differences between a small scale and a large scale retrenchment is a facilitator. So in a small scale retrenchment, this is not even possible. This is not even an option. You cannot have a facilitator. Now, does anyone, I'm going to just give someone an opportunity. What is meant by the word facilitator? What is a facilitator, or who is the facilitator? Does anyone know that? Who would the facilitator be in a large scale retrenchment? I'll just give you guys a moment. Okay, I don't think anyone knows. So it is a CCMA commissioner. So it's a completely independent third-party person. And, one of the reasons this was introduced was, you must keep in mind that we have certain large-scale retrenchments with parastatals, with large companies, private companies, your SABCs, telecoms, etc. And what our legislature tried to do is to try make the process a little bit more independent. Now, it's quite fascinating when you think about it, because a retrenchment should be between an employer and an employee. It shouldn't involve external parties. But when it comes to large-scale retrenchments, our legislature went and said, well, we're going to give this mechanism. It doesn't always apply. We'll go into when it applies. But there is a mechanism where an external third party, independent third party, being a CCMA commissioner, can facilitate the entire process. We'll get to what that entails, but I just want to highlight how and when this comes into existence. So the first possibility is the employer has in its notice, its 1893 notice, requests facilitation. So the employer could say, we want a facilitator to manage this process, and we want the facilitator to help us, to help, in fact, all parties with the Section 189 process. Or the consulting parties, representing the majority of the employees. We highlight majority because it cannot be, you remember, this is large scale. If less than 50%, so majority is accepted as 51% plus. If it's less than 50% of people that request it, it doesn't mean a facilitator will be appointed. It must be the majority. If they simply request facilitation and have notified the commission, that is the CCMA, that's the Commission for Conciliation, Mediation and Arbitration, within 15 days of the notice. Okay, so those are the two possibilities. Just the third one is you can obviously always agree, the parties can agree for a CCMA facilitator in terms of Section 189. But these are the two, you can always agree on anything. These are the two recognized in the section. The employer requests or the consulting parties representing the majority have requested facilitation, and there's a time limit as well. They must make this request within 15 days of receiving the 1893 notice. Okay, and then thirdly, obviously, you can always agree. So if that happens, then, the process changes quite drastically. And then the facilitator, governs and runs the entire process from start to finish, using the employer's 1893 notice, of course. So the employer still does the 1893 notice, but the CCMA commissioner helps manage it, runs the consultations, deals with alternatives, and it becomes an entirely different process. If a facilitator is not appointed, so so for example, if 1, 2, and 3 doesn't happen, because this is not a given 1, 2, or 3. So it's possible that these 3 possibilities don't come into existence, they don't materialize. Then the following applies. A party may not refer a dispute to a bargaining council or CCMA within 30 days, because with large-scale retrenchments, the consulting parties, either the trade unions or the employees, they may refer a dispute to the CCMA. But with a large scale, there's a 30-day bar. Employees may not refer anything to the CCMA within 30 days. So there's the first 30-day period. Then if a dispute is referred after the 30-day period, so, as I've said, the employees or the trade unions, they can lodge a dispute at the CCMA even prior to their dismissal. So they can say the process is unfair. They are disputing, the entire Section 189 process. Just keep in mind, this is not applicable in small-scale retrenchment. It's only applicable in large scale. They can dispute the entire process, but they can only do that after 30 days. So after the 30 days, they can refer a dispute to the CCMA, and then either a certificate of non-resolution has been issued or a period of 30 days thereafter has elapsed. Okay, so you need these two things to happen. Only once these two things have happened may an employer give notice to terminate the contract of employment. So you can immediately see how different the process is with large-scale retrenchments, because these two things need to happen. 30 days must lapse. Either they must refer a dispute, a certificate must be obtained, or a period of 30 days when the extension has elapsed since the referral was received by the CCMA, the employer may give notice. So it's generally accepted in our law that with large-scale retrenchments, you cannot dismiss within 60 days, 2 calendar months of giving the employees the notice. I'll just repeat that. It is important because if a dismissal occurs before in that period, it's automatically unfair, or it's clearly unfair. So there's a 60-day period that must elapse, basically 30 days there and 30 days here. Only then can an employer retrench, give notice to terminate. And before then, you cannot terminate. So a period of 60 days must lapse before issuing the notice and dismissal. And then a registered trade union or the employees who have received the notice so employees can go on strike. That's a concept that doesn't exist in small scale retrenchments. So they can actually go on strike just by receiving the notice or refer a dispute concerning the dismissal. So these are all concepts that apply only to large scale retrenchments. And you can see it's very different. It's very different to small scale retrenchments. And these employees have a wide range of options. And if they really want to, they can really challenge the process and make it exceptionally difficult by going on strike or referring a dispute to the CCMA even before they've been dismissed. That is a possible option, and our courts actually encourage that. They encourage that because we've had the toying strikes. We've had a lot of this where it goes into the public eye. And it reaches the news and it reaches the television stations. So what our legislation wants is that the employees have the option of going to the CCMA or a bargaining council and having them help facilitate. When I say facilitate, it's not a facilitator, but they can have a commissioner at least help resolve the dispute, to help either in the employer's favor or the employee's favor. But at least the employees have that option. I just want to pause here before we move on to just see if there's any questions on this issue, because this is quite different to the small scale retrenchment. So I'll just give you guys just a bit of a moment to see if there are any questions arising from this. Okay, thanks. It also gives me a moment just to have a bit of coffee, but I see no questions so far, so I'm just going to move on. Okay, just briefly, we're going to deal with the recourse available. If an employer does not comply with a fair procedure, a consulting party may approach the Labour Court by way of an application for the following order. Guys, I remind you, this is for large-scale retrenchments. And there's a section 189A 13(1)(3), where this is contained, and these are the options and the recourse available to employees or trade unions. They can approach the Labour Court and get an order compelling the employer to comply with a fair procedure, interdicting or restraining the employer from dismissing an employee prior to complying with a fair procedure. So quite literally, the court can stop an employer from retrenching someone until a fair procedure has been followed, directing the employer to reinstate an employee until it has complied with the fair procedure. So if, for example, someone has been dismissed already, prior to the employees getting the order from the Labour Court, the Labour Court can reinstate those employees back into the employment so that a fair procedure can be followed. An award of compensation can even be made. It's not always appropriate, and it says if an order in terms of the above is not appropriate. So these are the three that are normally obtained. And as a last resort, the employee could get compensation. It's difficult. Anything, I would say up to 12 months compensation if an order in terms of the above is not appropriate. So it's quite far-reaching implications if a fair procedure is not followed. And you know, the playing field changes quite drastically with a large-scale retrenchment because there are all these options available to employees and trade unions. Okay, I mentioned it earlier, and it's just worth highlighting that it's commonly accepted that with a large-scale retrenchment, once you issue the notice, there's a 60-day no dismissal period. Employees cannot be dismissed within 60 calendar days after the notice is issued to them. And if that does happen, it's automatically unfair. It's clearly unfair. So this is a strict requirement. We went through the 60-day period, but it's our courts just refer to this period of an automatic 60 days where they are protected. And in those 60 days, you are supposed to consult. Possibly the employees are given the opportunity to approach the CCMA, the bargaining council, possibly even the labor court during these 60 days. And it's just like a automatic veil of protection, if you will, given over the, which the employees enjoy in a large-scale retrenchment after the notice is issued. Okay, now just in closing, the last topic is we just have some general principles we want to touch on. The first one is that a lot of companies, it's not overly common, but a lot of companies have an entire dedicated retrenchment policy. Now, where there is such a policy, the companies must follow this policy, as a priority, because the policy firstly cannot be worse than what the Labour Relations Act or the Basic Conditions of Employment Act provides. So at the very worst, it'll be the same. But usually the policy is better, is more advantageous and beneficial to employees. So where there is such a policy, this policy must be followed. Now, and we highlight here that the policy cannot be less favorable than the LRA or the Basic Conditions of Employment Act. Where an employer fails to follow such a policy, even if it's compliant with the LRA and the Basic Conditions of Employment Act, the retrenchment may be unfair because the company hasn't followed its own procedure, which is contained in its own policy. So it sometimes catches some companies out because they forget. I'm telling you the truth. They sometimes forget that they have such a policy. So it's important to know, does the company have a policy to that effect? If so, it must be followed, failing which it may be unfair. It's just important to keep that in mind. Okay, this is a general requirement, and it applies more so to Section 189, the small-scale retrenchment. It's just the simple fact that there is no prescribed minimum or maximum number of consultations to be held or period within which the process must be concluded. And I'll just pause there because there is that reference to 189 and the 60 days. All that we're highlighting here is that with the small-scale retrenchments, it is possible that you could reach consensus and agreement in the first consultation. So you could conclude the process within a week. The point is that there's no minimum or maximum number of consultations that must be held or period that the consultations must last for. The requirement is that the process must be fair and that there must be a consultation process and that where possible you reach agreement. Now, it theoretically is possible that you could reach agreement and finalize all issues in the retrenchment in the first consultation. If you do that and there's an agreement reached, or at least there's consultation and consensus reached, then it remains possible that an employer can retrench within, let's say, 1 week of issuing the notice. It is possible. We just wanted to highlight that there's no prescribed minimum or maximum consultations or period. However, when it comes to 189A, we just spoke about the 60-day period. So there is a period prescribed where you must, for at least a minimum of 60 days, consult and try to reach consensus. So there is a difference there between the two sections. Okay, and I think I've said this before, the objective, and this is the objective, to achieve a meaningful joint consensus. That's the objective of the entire process. And it's not limited to timing or duration in the small scale retrenchment. In the large scale, we have the 60 calendar days requirement. And we even say here, this can in theory be achieved during the first consultation or any subsequent consultation thereafter. A single consultation will be viewed with scrutiny and skepticism. It is indeed common to consult several times with employees until all the mandatory issues are fully ventilated. However, depending on the circumstances, a single consultation may suffice. On the other hand, the employer need not prolong or entertain delays in the consultation process merely because employees are dragging their feet. Okay, so we're just highlighting there, we must be careful of which end of the spectrum we're at. We don't want to be too quick, but on the other side, we don't want to be too long either. You've got to sort of do a balancing act and land somewhere in between where an employer can show it's fair, we followed a fair process, and we have a record of the process followed. And it mustn't be a case of that we indefinitely extend the date of the dismissal. It's a balancing act must be achieved. We don't want to be too quick, but we don't want to be too long either. And if employees are dragging their feet, then, robust decisions must be made. Okay, then I think it's one of the last slides, if not the last slide. And it's an important issue to deal with in closing. What are the payments that must be made to retrenched employees? Okay, so these are the minimum payments to be made. We start with severance pay. Now, in terms of the BCA, the minimum payment is 1 week's remuneration for each completed year of ongoing service. So I did mention it earlier, and I'll just ask a general question, and anyone can respond in the comment section. How many weeks of severance will an employee get if they've been employed with the company for 3 years and 10 months? 3 years and 10 months. Will they get 1 week, 2 week, 3 week, 4 weeks? If we apply 1 week's remuneration for each completed year of ongoing service, yes, Louise, correct. For purposes of severance, you ignore the 10 months in this example. It is 3 years and 10 months. Even if it's 11 months, they get 3 weeks. It's unfortunately, you round down, you don't round up. It's for completed years of service, not uncompleted years of service. And as we established earlier, it's calendar. The remuneration taken into account is basic salary, payment in kind, and discretionary payments related to working hours performance. Look, this shouldn't get too complicated. You just look at an employee's salary. If you want to take the cost to company package or salary, it should be the basic salary. There is a directive dealing with this, but it's much easier to deal with the employee's salary. If there's commission involved, you take the last 3 months and you get an average. So if we now are in June, you would take March, April, May. You take those 3 months because it varies. You divide it by 3 and you get an average. And that's in terms of Section 35 of the Basic Conditions of Employment Act. So you can work out what an employee's monthly remuneration is, get the week, divided by 4.333, and then you get a 1 week salary. And that's the severance pay. Also, just I think of particular interest to yourselves, there is a tax benefit for severance pay. Every person, and I can double check. It may have gone up recently, but traditionally it's been for every person they enjoy tax-free severance for up to the first 500,000 Rand in their lifetime. So if someone gets retrenched multiple times, they can enjoy severance up to a maximum of 500,000 Rand tax-free. So that no tax must be deducted from the severance portion received by the employees. You may or may not be aware of that, but it's a nice benefit, and that's just SARS, saying to the employees, you've just lost your job. We're sorry, we feel sorry for you. At least we're not going to take tax from your severance payment. So it's up to 500,000 Rand. I'm not exactly sure if it's recently gone up, but we've always known it as 500,000 Rand in a person's lifetime. Once that's exhausted, unfortunately, then any severance pay thereafter is taxable. Just an important point to raise here, and it's contained in Section 41 of the Basic Conditions of Employment Act. It's the second bullet here. Employee not entitled to severance if they refuse a reasonable alternative. Now, in a Section 189 process, an employer may offer a reasonable alternative position at a slightly lower salary. The question is it a reasonable alternative? Now, obviously, the question reasonable, it is a little bit subjective, and it's not always easy to determine or agree on what's reasonable. But obviously, a CFO of a company, you can't offer them a receptionist position. It has to be a reasonable alternative, and often it comes at a lower salary. But if that reasonable alternative is offered to an employee, and that employee rejects it, refuses it, the employer then is entitled to withhold, in other words, not pay the severance pay, because the employee refused a reasonable alternative to the retrenchment. So plainly put, an employer tries to avoid the retrenchment, offers a reasonable alternative, as long as it's reasonable, and the employee rejects it, then the company can say, well, we're not paying you severance pay because we gave you a reasonable alternative and you rejected it. So it's an important criteria to keep in mind, and it's listed, it's stated in Section 41 of the BCA, this requirement. That's where it comes from. Section 41 of the BCA, employee not entitled to severance if they refuse a reasonable alternative. Then notice pay. This is usually contractual. In other words, if an employer's, if the employee's contract of employment says that they have 3 months notice, it's, sometimes it's 3 months. I've seen notice pay up to 1 year, 12 months. Whatever that notice pay is in the employee's contract of employment, it must be paid by the company when the employee is retrenched. If there is no employment contract, or if it's not, if there's no notice pay in the contract, then you follow the section in the Basic Conditions of Employment Act, Section 37, and there's a scale there. It's, if the person's been employed for 6 months or less, it's 1 week. 6 months to 12 months, it's 2 weeks, and anything more than 12 months, they're entitled to 4 weeks. I think most of you will know the scale. I'll just repeat it one more time. If they've only been employed for less than 6 months, it's 1 week. If it's between 6 months and 12 months, it's 2 weeks notice pay. And if it's more than 12 months, it's 4 weeks notice pay. And that's if there's no contract that stipulates notice pay. If there is a contract, you follow the contract. And unfortunately, sometimes the notice pays are big, 3 months, 6 months, I've seen up to 12 months. That must be paid on top of severance pay. the employee must also be paid their annual leave. You don't pay out sick leave or family responsibility leave, maternity leave, paternity leave, all of that. It's only annual leave, the annual leave standing to the employee's credit as at the date of termination. And just to be clear, these are all cumulative. You have to pay severance plus notice plus annual leave standing to the credit. And then just other, there might be accrued bonuses, pro rata payment of bonus, pension, provident fund. Obviously, anything else that's due to an employee in terms of the employment bonus, provident pension must also be paid to them. It's hard to just list. It may depend on the relationship between the parties, but whatever else is due to them must be paid because the contract is coming to an end. The first three are the most common. Just in closing, and this is the last point, just to refer you to section 84 of the BCA. And I'm just going to tell you verbally what that section provides. Now, it speaks to each completed year of service and severance pay. Now, this section 84 in the BCA states, if someone terminates their employment, okay, but they regain employment with that employer within a period of 12 months. So, practical example, someone resigned in February. Louise resigned in February 2020, but he came back to the company in November 2020. So within 10 months, he's within the 12-month period. If the employment is terminated and resumes within a period of 12 months, then there's no break. There's no break in continuous employment with that company. And that includes that there's no break. So then that person will be entitled to severance pay, inclusive of their total employment. I hope that makes sense. I can clarify it a little bit more and let me know if you have questions. Basically, if someone leaves and joins within a period of 12 months, there's no break in the chain. If they've been there for 10 years prior, those 10 years remain, and that employee will get severance for all 10 or 11 years, depending on when the retrenchment is, as long as they rejoin the company within a period of 12 months after resigning or being dismissed. Okay, and that's a section that not many people are aware of, and it's section 84 of the BCA. It's this 12-month period. If it's outside the 12 months, obviously then there is a break in employment, and then you start afresh. You lose all of your previous years of service. So if someone joins 2 years later, they start on 0 years. You don't take their previous years with the company into account. Okay, guys, and that's it. That concludes the presentation. We've just left a slide here for questions. If anyone has any questions, it's about 11:45, so I think we've ended at a nice time. And yeah, I'll just wait a minute or two if anyone has any questions, which either they can do in the comment section or just on the microphone live. Thanks, guys. Yeah, I see your messages. Thank you. It was a pleasure. Doesn't look like there's any questions. So yeah, Blaise. Thank you. Yeah, thank you. I hope it was useful. We've shared the slides. And if anyone ever has any questions, you can reach us through Blaze or direct, I'm not sure. And yeah, thanks everyone. I'm going to stop sharing, and yeah, I guess we can leave the chat. Thanks everyone.